So I'll speak on numbers 11, 14, 15, 16 and 17, all of which deal with the section of this bill that's meant to tackle SLAPs, so that's strategic lawsuits against public participation. Now, I want to be very clear from the outset. I welcome the fact that the Government has finally acknowledged the need to address SLAPs, but what we've been given here is a half-hearted attempt. It's a framework that looks good on paper but lacks the teeth to actually protect people who speak out in the public interest. These amendments I've tabled is not just my own ideas. These are based on the recommendations of the Ireland Anti-SLAP Network, a coalition of organisations which include journalists, NGOs, legal experts and civil society groups who have been raising the alarm on these issues for years. They know what's happening on the ground. They've seen the chilling effects these lawsuits have on whistleblowers, campaigners and ordinary citizens. Let me give a hypothetical example. Imagine a resident in County Meath or Clare or Donegal raised concerns about illegal dumping by a very powerful company. That person posts it online, they speak out to the local papers, they attend a local council meeting. Next thing she knows or he knows, they're hit with a defamation suit. The company isn't really interested in winning. They just want to shut that person up. They want to drain their bank account. They want to wear her down and send a message to anyone else: stay quiet or you'll be next. That's a slap. And under the government's current wording, such a person might be dragged through the courts for months or years before a judge even considers whether the case is abusive. That's just not good enough. So Amendment 11 strengthens the definition of what counts as an abusive court proceeding. Right now, the bill focuses on the purpose, the purpose of the lawsuit, what the plaintiff is intended. But that's not hard to prove. My amendment shifts the focus to the effect of the lawsuit. And if it has the effect of silencing public participation, that should be enough. Intent can be hidden, impact cannot. Amendment 14 ensures that when someone applies to have a slap struck out, the court deals with it quickly. Justice delayed is justice denied. If someone is being silenced by a bogus lawsuit, they shouldn't have to wait a year for a hearing. The court should act as expeditiously as possible. That's not just common sense, it's basic protection. It also removes the manifestly unfounded barrier for the defendant, which has near unanimously been criticised as a threshold so high it nullifies the entire point of the anti-SLAP protection. Amendment 15 removes a section that could allow unnecessary delays and procedural games. It's a clean-up amendment, but an important one. We need to clarify and speed up in these cases. Amendment 16 introduces an automatic stay on the proceedings once a SLAP application is made. This means that the plaintiff can't keep pushing the case forward while the court is still deciding whether it's abusive. It also stops them from sneakily changing their proceedings to get around a dismissal. Again, this is about stopping the abuse of process. And Amendment 17 puts in part of the burden where it belongs, on the claimant. If they want to continue with their case, they should have to prove two things. First, that they're likely to win at trial, and second, that the harm they've suffered is seriously enough to outweigh the public interest in free expression. That's a fair test, it's balanced, and it's already used in other countries. Now, I want to say this, that the government's version of these provisions is weak, it's vague, it leaves too much discretion to the courts without giving them the tools they need. It's like giving someone a map with no compass. We need clear definitions, firm procedures and a real consequence for those who abuse the courts to silence others. If we're serious about protecting democracy, we need to protect the people who speak up: journalists, activists, community leaders and even just regular citizens. They are the lifeblood of public discourse. They shouldn't have to choose between telling the truth and keeping their home. So I urge the Minister to take these amendments seriously. They're not radical, they're reasonable, they're grounded in expert advice, and they would make this bill stronger, fairer and more effective. Thank you.